Module H, the summary of the argument. We're going to talk about 5 tips for crafting an effective summary of the argument. Tip number 1, write your summary before you write the argument. Use this as a tentative outline for your argument. Tip number 2, rewrite your summary after you've fully developed your argument. Tip number 3, keep it succinct, clear, and accurate. Do not simply repeat argument headings. The Supreme Court's rule on this may actually lay it out best, and I quote, "The summary should be a clear and concise condensation of the argument made in the body of the brief. Mere repetition of the headings under which the argument is arranged is not sufficient." Remember that your purpose is to give judges an immediate sense of overview. Keep it short, but in real paragraphs. Tip number 4. If you've ever written a business report, think of this as an executive summary. Executive summaries are usually a section of the document produced for business purposes that summarize a longer report in such a way that readers can rapidly become acquainted with a large body of material without having to read it all. Think Cliff Notes. It usually contains a brief statement of the problem covered in the report, some background information, concise analysis, and main conclusions. It's meant to help managers make a decision. Executive summaries should include the major details of the report, but it's important not to bore the reader with minutiae. It's important for you as well as the writer to determine what aspects of your report have the clearest selling points and which aspects may require a bit more explanation. This exact same idea that applies to an executive summary applies to the summary of an argument. Tip number 5. Make the connections between legal, factual, and policy issues with what the trial court did and what the appellate court can do for you. Do not forget that what happened in the district court is what brings you here on appeal. Let's take a look at one example of a summary of the argument. The district court erred in interpreting 11 U.S.C. 521A2 as limiting a Chapter 7 debtor to 3 options regarding secured collateral: surrender the collateral, redeem the collateral, or reaffirm the debt. The Griffins chose to retain their boat and reaffirm the debt on the original contract terms. This option, known as reinstatement, is consistent with the meaning and purpose of 11 U.S.C. 521A2, as well as the fresh start policy of the Bankruptcy Code. The plain text of 11 U.S.C. 521A2 allows a debtor to choose an option not explicitly listed in the statute. If Congress had meant for the statutory options to be exclusive, the phrase, "if applicable," would be redundant. This proposition is strengthened by the 2005 amendments, which added a provision that specifically provides protection to debtors who choose to retain their collateral and reaffirm debt on the original contract terms. Additionally, legislative history indicates that the statute was enacted as a notice provision, not meant to substantially alter a debtor's rights. Even if the court finds the statutory language ambiguous and the legislative history unpersuasive, there's a strong policy argument for allowing the Griffins to choose reinstatement. The Supreme Court has reaffirmed the policy underlying the Bankruptcy Code as one of a fresh start. The Griffins cannot afford a change in the terms of the loan, nor can they redeem the boat. Therefore, limiting the Griffins to the options in the statute would effectively force them to surrender their boat, leaving them homeless and without a source of income. Since the Griffins remain current on their loan, Quahog is not harmed by the Griffins' decision to retain their boat and reaffirm the debt on the original loan terms. For these reasons, the Griffins respectfully request that the order of the district court be reversed and that they be permitted to retain their boat by continuing to perform under the original terms of the loan.